the government can also check, my, communication on WhatsApp or on Zoom right now, the platform that we're using. And there are certain legislations in place that give the union government the power to say suspend the internet, or give the government the power to intercept, your communication online. So that can be, your calls, your messages. The Telecom Act introduces duties on users. And interestingly, if I don't abide by my duty, there are penalties that, I can face.
Today with me on this episode of Unbreak the News is Tejasvi Panjiyar, who's the Associate Policy Counsel at the Internet Freedom Foundation. Tejasvi has been advocating for digital rights for years. Tejasvi, thank you for joining me.
Good to be here.
Yeah. Tejasvi, in December 2023, when most of the opposition MPs were suspended in Parliament, the Lok Sabha passed the Telecommunications Bill 2023. Now, this bill replaces three archaic laws: the Indian Telegraph Act of 1885, the Indian Wireless Telegraphy Act of 1933, and the Telegraph Wire Act of 1950, and it brings all telecom regulations under one act. You have called in the past the new telecom law outdated and archaic. What exactly do you mean when you say this?
Thank you for the question, and thank you for setting the context. I think the reason that we've consistently called, I say consistently because we've seen two versions of this bill. So we saw the 2022 version, and then we saw the 2023 version, which was placed in the Parliament. I think even if you read the white paper that came right before the 2022 bill, there was a white paper that was released by the government, a good step, I would say, a positive step. I think the intention of sort of repeal existing legislation was to bring about reform in the sector, reform in the telecom sector. And I think there was general agreement that this could be a step in the right direction, because we've seen a lot of changes since. And currently, the legislation that we have that will now get repealed do not have provisions to legislate surveillance in the country, do not have internet suspension safeguards. We have certain rules, like we have the TSTS rules, and there are certain legislations in place that give the union government the power to say suspend the internet, power to intercept, your communication online. So that can be, your calls, your messages. So it does give the government the power. But what we also need with something like that, and I think anyone would agree with that, is safeguards that are situated in the legal framework, so that are written in the word of the law, that are user-centric, that are rights-centric. We need checks and balances. So if we have, because I'm sure we've heard about a lot of instances of internet shutdown and surveillance in the recent past. We had Pegasus, we had recently the Apple threat notification incident. We've had modified elephant in the past. These are all surveillance instances. So we've had internet shutdowns during protests, during major civic movements. So when we are seeing how these powers can be used and misused, I think it's very important to bring in safeguards and citizen-centric rights into the conversation. We were talking about the same thing that they were talking about. The intent was the same, to bring about reforms, but what it did was it copy-pasted the sections of surveillance and internet shutdown, and it's almost identical to the Telegraph Act.
To put it in perspective, the government actually said that these three old laws were archaic, and so therefore we needed a new law that's going to bring in more reformation. But what you're saying is, instead of reforming the existing laws, what the government has done is gone back and made it more archaic. So if you can point out specific clauses or specific sections of this new law and say what makes it really archaic, then probably it will be more interesting for the audience. Yeah.
Absolutely. So first thing, which is almost identical, is Section 20 of the Telecom Act. It's almost identical to the Section 5 of the Indian Telegraph Act. Now, we also have an image, I think, where we put it side by side. These have to pertain. These basically, Section 20 pertains with surveillance, interception, and suspension of internet communication. The wording and the phrasing is exactly verbatim the same. So those colonial provisions have been introduced without any oversight, accountability, safeguards, etc. Another thing, the reason why I say it's archaic is because there are certain introductions that, again, give the executive very overbroad powers. So, for instance, Section 43 confers quasi-judicial powers to any officer that is authorized by the union government. So that is also a sort of a gray area, right? If any officer authorized by the union government can essentially search any building, vehicle, any like telecommunication service, um, which is in possession on XYZ grounds, right? They also have not just searching powers, but they also have seizure powers. So they can actually seize your entity. These include information, documents, records, and they can keep it in the possession of the union government. Um, and this they've done for any pending or apprehended civil or criminal proceedings. Now that's interesting, right? It's not just any civil or criminal proceedings that have had a judgment, but any pending judgments also they can use, take those cases and get any um, documents or information that they need to. And I think the reason why we as a digital rights organizations are focused on these provisions so much is because right now there's this lack of clarity as to whether online communication services are included in the scope. If, say, the Telecom Act covers, say, online communication services like WhatsApp, then the government can also check, my, communication on WhatsApp or on Zoom right now, the platform that we're using. So whenever we're talking about these provisions, when we talk about surveillance and interception of messages, and encryption, so another clause, and I'll have to just quickly check, but I think 19F, Section 19F says that the government has the power to notify encryption standards. Now this is on grounds of public emergency and in the interest of public safety. So I think you can imagine how the interest of public safety ground can be prone to misuse. And encryption is a very key and core sort of core aspect of any communication service online, like WhatsApp, like Signal.
Yeah, you've said that there is a lot of ambiguity around the scope of the provisions. Now, what exactly do you mean when you say that there are a lot of gray areas, or what are the ambiguous parts of the new law?
Right. So this whole conversation started in 2022, wherein in the bill, it's sort of the way telecommunication services was phrased, it sort of expanded scope to online communication services. And that led to a lot of backlash and a lot of concerns because that meant increased regulatory burden, compliance burden, cost burden. But yes, all of that, but also diluted user safety, increase in executive surveillance powers, etc. So that's what I think.
In layman's terms, what does it mean? For instance, if a common man is watching this,
right,
how does this infringe upon his rights whenever he uses the mobile phone, or he's on Skype, or he's on WhatsApp? How do these new laws really infringe on his personal privacy rights or data protection related rights?
Right, absolutely. So right now, if you and I are messaging over WhatsApp, it's end-to-end encrypted, which means no one else, not even the owner of WhatsApp, knows the content of our messages at the very least. If, say, the Telecom Act, as it is applied to communication services like WhatsApp, Zoom, Facebook Messenger, any communication service you can think of, even Skype, right? Because it allows us to chat. The government can extend its surveillance powers, its suspension powers to these platforms, which means now the government can say, okay, in the interest of, in public interest, I need to check the contents of your messages. So I'm breaking down end-to-end encryption because Telecom Act allows me to, to bring about encryption standards. So I'm breaking end-to-end encryption. So I now have backdoor channel to your earlier encrypted chats. I can suspend WhatsApp. So now I'm sure several people in the country have witnessed internet shutdowns because we've seen this in Rajasthan, West Bengal, Kashmir, so many other states. So right now, if you have an internet shutdown, obviously you're not able to access any online communication services. They can, if the Telecom Act is applied to, say, online communication services, they can also say there's a protest going on, there's a lot of misinformation or fake news, quote unquote. So we are going to selectively take down certain applications because we have the power to do so. We are going to take down WhatsApp, we're going to take down Signal, we're going to take down Facebook to, in public interest.
So does
I
does
mean,
the act
it's endless.
does the new law actually say that the government can read our WhatsApp messages, or even access a Zoom conversation or a Skype conversation? If yes, then these service providers and these platforms also need to agree to this, right? Because tomorrow, if the government wants these service providers to comply, then they must. So, what is the status of the service providers also complying to these requests from the government, or probably complying to the new law?
Think that's where the tricky part is. Like, that's where the ambiguity comes in. Is because where in the 2022 version, it was quite clear that the scope was expanded to online communication services. What they've done in the 2023 version is they have heavily sort of diluted the definition of telecommunication services. So now, if you read certain definitions under the act, it does not explicitly say that, okay, this will apply to XYZ communication services or even online communication services. It doesn't say that. But the definition is so ambiguous and it's so open ended that it does, in fact, and given the history with the 2022 bill, it does leave the scope wide enough for online communication services at one point in the future to be included. So at this point, we're even fighting that. Added in the letter of the law itself explicitly that online communication services are and will not be included in the scope of this act, and hence surveillance, possession, suspension, authorization, interception provisions will not apply to internet services.
Yeah.
Right now, it does not say that.
Yeah. So, Tejasvi, the government very recently said that the new Telecom Act is ready for a partial takeoff. Now, what does the government mean when they say a partial takeoff is going to happen, and why not a full takeoff? And what are the provisions of this bill that will now come into effect, and how is this going to impact the citizens?
So I don't think the government either has explained their rationale for a partial, notification. It's I think usually based on several factors, compliance to ease compliance burden for entities, government's readiness and preparedness itself to roll out this act, etc. So I guess not really sure if I can go into why the partial notification, but definitely in terms of the sections that are coming into effect and their implications. The one that we've spoken about at length is definition. The definition clause is definitely coming into effect. So that's section 2. That's a big one. The other one that's coming into effect, very, something of note, is the Telecom Act introduces duties on users. Now, this is something we've never seen in legislations previously. Right now, with the Data Protection Act and now even with the Telecom Act, both passed last year, we're seeing new duties being afforded on users. So now, not only like if and interestingly, if I don't abide by my duty, there are penalties that I can face, and some of the duties are really egregious. So it's for instance, I have, as a user, and now that it's gone into effect, I have a duty to not furnish any false information while I'm establishing my identity to avail any telecommunication service. So, say if Telecom Act is expanded to Instagram and it's applicable on Instagram, and I want to create an account, but I want to remain anonymous, which most communication services give me the ability to do. I will not be able to do that, because if I do that, I'm failing my duty as a user under the Telecom Act, because I'm furnishing false information, and I can get a violation. I think there's some penalty at to I'll have to check. I think 10,000 rupees, but there's definitely a penalty provision as well. So I mean, it has a damaging consequence for a user's ability to stay anonymous. You can imagine.
When you talk about this particular clause, are you talking about clause 29? Because this particular clause is going to be problematic for journalists and whistleblowers. Are you talking about the same clause?
Absolutely, section 29.
Exactly. So what legal recourse do journalists and whistleblowers have to counter this?
I would say the first would be, so right now you have to understand this will only happen if it applies to online telecommunication services, right? Online communication services. So at that point, say if in the future they bring out certain rules and say now the definition of telecommunication includes online communication services, then I think the legal recourse could be And this is unfortunate because it's not always an accessible recourse, but going to the courts to sort of challenge that it's ultra vires, the act itself, because the act never really envisioned expanding the scope by this much.
Hmm.
So I think that would be the only recourse, to essentially go to court. And again, I'm not a lawyer, so I think better answered by a lawyer there.
Yeah.
But from a policy perspective, I think that's why we're pushing for a change and reform in the language of the act to make it very explicit, so we can, safeguard our journalists, whistleblowers, and many other people who rely on anonymity online.
Hmm. So clearly,
Vulnerable communities.
yeah, so clearly there are a lot of gray areas. Now, your
Yeah.
organization, the Internet Freedom Foundation, has constantly spoken in the past about how we need a more rights-centric law that protects users'
Yeah.
rights instead of infringing them. What should have been the ideal bill according to you? What should the new law ideally address?
Um, Well, great question. First would be just to alleviate any fears around this expanding, the scope of this act expanding to online communication services, because we are seeing so many people now, move on to online platforms like WhatsApp and Zoom, and it's given them so many opportunities, not just anonymity but accessibility. I think these are way more accessible now that we're seeing increasing tariff prices, etc. Given all of that, I think to just put this conversation to rest, that the government does not intend on doing so, because on one hand the minister will say we don't intend to do that, on the other hand there's a statement by additional secretary of the DOT saying it's undecided, and that's really scary because it's very, very recent, that statement. So I think that would be one that in itself would be a right centric step to take. The other would be, like I mentioned, surveillance and internet shutdown and suspension reforms. um, there are certain reforms in certain legislations that talk about, for instance, there's an internet shutdown. This needs to go to a review committee who will review, whether the suspension was, the decision to suspend the internet was right or wrong. Interestingly, the review committee in itself does not have any powers. So even if they can review it, they can't act on their decision. Now, these are the kind of reforms we need. If say a government is saying there's exams and we want to prevent cheating, so we'll shut the internet for the entire area of the state, that needs to be reviewed on grounds that are listed. Those grounds firstly need to be proportionate. That needs to be the decision needs to be reviewed. It's not just the decision itself, but how long is the suspension for? There are many factors, right? That needs to be reviewed. Surveillance, same thing, right? There needs to be safeguards built into these powers. So there needs to be checks and balances, some level of transparency. You can't get any information under the Right to Information Act. You can't, when Pegasus was taken to court, everything was done in sealed covers. So the public does not really have a knowledge as to what the investigation revealed. These are the kind of safeguards we need to build into a Telecom Act. Very, very important. And ultimately it's for the safety of users, yes, but so many vulnerable communities. You mentioned journalists and whistleblowers, but so many marginalized communities as well. So it's for their safety as well. Because we see usually journalists our protesters being targeted through shutdowns, through surveillance. So yeah, I think these are some reforms, primarily surveillance and shutdown reforms.
So if you can talk about three top concerns that you have, three most shocking or probably problematic areas that you have with the new law, what would they be?
The first would be, I mean, I know it's an act of parliament, but I'll just say that the way that this act was brought in, we follow parliament every session, and we had not expected this to be brought in the winter session. 2020 through 2023 version of the bill was not put for public consultation again, because it was a revised version. It should have. So I would just say the parliamentary proceedings were not respected and not followed. There was minimal debate on the bill, and half of the parliament was not there. They were suspended. So that was the biggest and the most shocking thing. First and foremost. Second is the fact that the scope of the act is not clearly defined, and that's extremely concerning, because if it is in fact going to be, if the scope is going to apply to online communication services, then there are a whole range of issues that we need to get into and fight against. And the last would be, the lack of reforms for surveillance and internet suspension architecture. I think that should have been the whole point of a reform, of a repeal. but I think that was missed altogether.
It's not very right-centric, no? So, Tejasvi,
No.
most of these laws have traditionally been used to do surveillance of the devices of citizens, including journalists. You've been speaking about that. What are the specific sections in the new law which the citizens and journalists should be worried about when it comes to privacy and data protection related issues?
I would say section 19 and 20. Entirety of 20 essentially gives governments power to either possess your device or suspend it, intercept any communication, and then directly suspend any telecommunication service, which is internet shutdowns. Now, also that uh, since you spoke about privacy, since now it has a new standard for a new provision for uh, introducing encryption standards, one should also be worried about, uh, currently have the freedom to use encrypted platforms and have our communication secure. That is also something that everyone who worried about their privacy online should be looking out at. Section 19 and 20, most definitely.
How do international telecom regulations typically handle user privacy and data protection? Can you give us some specific examples of countries that are leading in this area, and what can India learn from them?
I'm sure that, while most jurisdictions have surveillance and internet suspension powers and provisions, they do, but there are also, corresponding rights based safeguards built into the law as well. And I think that's something that they should borrow from uh, jurisdictions that do, have their laws structured like that.
Yeah. Do you think that there is a room for future amendments to the Telecom Bill 2023 to address its current shortcomings? If so, what specific changes would you advocate for?
Well, I guess there is scope for amendment of any act of parliament. Um, I guess the first way to do would be to have a meaningful discourse in the parliament itself. I'm sure a lot of members of parliament have a lot to say about the bill. An act of which is now an act of parliament, almost notified. Um, but I think definitely the duties on users, that's something that should be looked at. I will say that the 2022 bill had more duties on users. One of them was done away with, so that's a positive step. Um, but there still is this new duty to not furnish any false information that should be relooked at. An amendment should be brought in urgently to explicitly keep away any online communication services from the scope of the act, and this should be done as soon as possible. And I would say the biggest one, and mentioned this a bunch of times, is the powers that are given to the executive. They need to be amended to introduce certain right-centric safeguards.
Yeah. The last question that I want to ask you is, Tejasvi, what can ordinary citizens do to advocate for their digital rights in light of the new telecom regulations? How can they make their voices heard? If citizens or journalists feel that their rights are being infringed upon under the new law, what legal recourse do they have? Or are there any existing legal frameworks or mechanisms to protect them?
Like I said, there's the court, and I'm not very happy to say that because it's not very accessible. Like you mentioned, like citizens like you and I, if we are affected by this law, or even are seeing someone else or larger communities being affected by it, I think at this point, since it is an act of parliament now, we'll soon see rules being notified. The only thing to do is take this to court, especially if it starts being ambiguously misused and scope of it starts expanding to beyond a point at which it is currently envisioned. At that point, we'll have to look towards judicial recourse.
Thanks a lot, Tejasvi, for the insights. It was wonderful having you on the show.
Thank you for having me.
Thank you.